Welcome to the Deep Dive. We take fascinating source materials and, well, we dive deep, pulling out the insights that matter so you can be truly informed.
That's the goal.
And today, we're pulling back the curtain on something maybe a bit counterintuitive in the American legal system. It's this unseen tension right there in the halls of justice. Imagine this. You're in a courtroom, maybe a federal court somewhere, and the judge makes a ruling, and to a lot of people watching, legal experts even, it looks like it directly challenges an order from the Supreme Court itself.
Right.
How does that even happen in a system that's all about hierarchy, about precedent?
Well, that's exactly where it gets fascinating, isn't it?
Right.
Because this isn't just, one rogue judge going off script.
Okay.
It's really a window into the whole structure, the philosophy behind our judiciary. It's this tension that plays out constantly, often, behind the scenes, away from the headlines.
And that's exactly what we're diving into today. We've got this specific case highlighted in our sources. It's about a lower court judge accused of, well, defying a Supreme Court order.
Yep.
So our mission today, using insights from judicial defiance, authority, independence, and interpretation, and also judicial defiance, authority, interpretation, and trust in the courts, is to really dissect this balance, this critical balance between the Supreme Court's authority and the independence that lower court judges need.
Exactly. We'll dig into why those Supreme Court orders sometimes aren't crystal clear, the kind of pressures judges are under when they have to make these big calls.
Right.
And really importantly, what all of this means for public trust. Trust in the whole system. We want to get to the heart of what works and what maybe needs a closer look.
So get ready. This is a deep dive that goes way beyond the headlines. It'll give you, hopefully, a much richer sense of how justice actually gets delivered, often amidst some really tough legal knots and ethical questions. Okay, let's jump right in. The heart of this whole discussion is this case our sources bring up. Let's imagine a judge, maybe a federal district judge. Let's call her Judge Anya Sharma. Sharp, committed to the law. Yeah. But she finds herself right in the middle of a storm, accused of directly defying a Supreme Court order. And this isn't just a minor thing, is it? It's a serious charge. It suggests she deliberately ignored the judicial hierarchy.
It's incredibly serious. And the specifics, according to our sources, center on what we're calling the Minerva Order. This was an emergency directive, a temporary restraining order, or TRO, from the Supreme Court.
Okay, an emergency measure.
Right. In response to this really controversial new federal policy, let's say it dealt with immigration. It was having immediate big impacts, maybe restricting travel, affecting families. The Supreme Court's order was meant to stop or at least change parts of that policy.
Quickly.
Got it. Halt the controversial policy.
That was the intent, seemingly. But Judge Sharma, faced with this order, she interpreted it and made a ruling in her court that, quote, was deemed by many to be in direct opposition to the higher court's ruling.
So not following the spirit of the order, or the letter.
Well, the accusation was more like interpreting it so narrowly, so technically, that it kind of sidestepped what the Supreme Court seemed to want, allowed some of the policy's effects to continue, maybe under the radar of strict compliance.
Ah, okay. So it's subtle.
It can be. But the implication is huge. It's not just a procedural error. It hits right at the core of how the system functions, the expectation that lower courts follow the Supreme Court. It disrupts that whole idea of consistent federal law.
Just think about the pressure on Judge Sharma. You're sworn to uphold the law, then bam, you're accused of ignoring the highest court. Intense scrutiny, right?
I mean, it's like, imagine a general getting a direct order from the top brass, the Pentagon, and then interpreting it in a way that changes the whole mission on the ground, causes confusion, looks like insubordination.
That's a good analogy. The potential breakdown is significant.
And for you listening, think about the implications. If one judge can sort of reinterpret a Supreme Court ruling this way, what happens to, the law being the same everywhere in California versus Florida, say?
Exactly.
That idea of uniformity, of predictability, it starts to fray, doesn't it? Threatens that core principle of equal justice.
You've absolutely nailed a critical point there.
Yeah.
Uniformity isn't just some bureaucratic neatness. It's vital for public trust. People need to know what the law is, what their rights are. If it changes wildly, depending on where you are or which judge you get, the system loses legitimacy. So this accusation against Judge Sharma, it's disruptive precisely because the whole system relies on that hierarchical integrity. When that's questioned, it shakes the foundation. It's way more than just a judge possibly getting disciplined. It's a challenge to the authority of the entire federal court system.
But here's where it gets really tangled and, frankly, fascinating. Our sources reveal that the Supreme Court's original order, this Minerva order, well, it wasn't exactly crystal clear itself. It was, and I'm quoting here, to put it mildly, subject to varying interpretations.
That is such a crucial piece of this puzzle.
So the intent might have seemed clear to some, like the scholars watching, but the actual wording, it had, quote, nuances and potential ambiguities that allowed for alternative readings. There was wiggle room, basically.
And that's a really powerful reminder, isn't it? That even rulings from the very top, especially emergency ones, aren't always perfectly airtight. They don't always shut down every other possible way of reading them. The language can be dense, technical. Crafted carefully, yes, but maybe still leaving gaps. And think about the context. These emergency situations demand fast action.
Right, speed is key.
Exactly. Sometimes decisions are based on incomplete information. That pressure, the need for the justices to agree quickly, it can, well, inadvertently create these interpretive gray areas. So you get a situation where a lower court judge, like Judge Sharma, might genuinely believe they are following the order's text, even if the overall intent from the Supreme Court was maybe different. And the stakes for getting it wrong, huge.
Okay, let's unpack that a little. How do the justices balance that? The need for absolute precision in legal language versus the urgent need to act now.
It's a constant challenge.
Could that need for speed sometimes, compromise the clarity? Could it actually set up lower courts for this kind of mess?
Well, it's a possibility. It's like being handed, complex instructions for defusing a bomb, but some steps are a bit fuzzy.
Yeah, exactly.
If everything depends on getting it exactly right, that fuzziness is a massive problem. And this ambiguity, as we'll see Justice Breyer suggest, it gives us crucial context for Judge Sharma's actions. It complicates the simple narrative of defiance.
It's this perennial tension in legal drafting, isn't it? Especially at the appellate level.
Absolutely. If you try to make an order absolutely exhaustive, covering every possible contingency, it takes a huge amount of time. Drafting, negotiation, getting 9 justices on the same page.
Right, 9 different perspectives.
Exactly. But if you go for speed, the order might be less precise, and that inevitably opens the door for disagreement, for different applications down the line. It really highlights the human element, the interpretation part. It's not just plugging words into a machine.
And for Judge Sharma, if she is found to have defied the order, the consequences, our sources say they're potentially severe.
Oh, absolutely.
We're talking, quote, from significant fines to suspension from judicial duties, potentially even impacting her career trajectory and professional reputation irrevocably.
The gravity of finding a sitting federal judge in contempt. It's hard to overstate. It's not like a parking ticket.
No.
It's a fundamental challenge to their standing, their credibility, their moral authority. It could trigger ethics investigations, maybe even impeachment talk. It casts a long shadow.
Wow.
So that prospect alone is a powerful deterrent against, flagrant defiance. Because it strikes right at their professional core, their impartiality, their commitment to the rule of law. It signals a serious breach.
And it makes you, the listener, think about what those penalties are saying, right? About how vital it is to respect that hierarchy, to uphold the rule of law within the system itself. It's not just about one judge. It's about keeping the whole judicial branch coherent, making sure there's a clear, enforceable way that law flows from the top down.
Precisely. Maintaining the integrity of the entire structure.
Okay, so this situation is complex, high stakes, and then enters a crucial voice, Justice Breyer. Our sources point to him, known for his, quote, thoughtful and pragmatic approach.
Yes, a highly respected figure.
And he commented publicly on Judge Sharma's case and offered, quote, a nuanced perspective. This kind of reframes the whole thing.
And here's where it gets really interesting. Justice Breyer, he didn't explicitly excuse Judge Sharma's actions, let's be clear.
Okay, not condoning it.
No. But he did, quote, suggest a possible ambiguity in the Supreme Court's initial order. He basically argued that her interpretation, while maybe, quote, unconventional, wasn't necessarily this blatant act of rebellion. Instead, he suggested it might have been, quote, a result of a less than crystal clear mandate from the highest court. His point seems centered on just how complex interpreting these emergency orders can be.
Right.
He hinted that the intense pressure, the urgency, might have genuinely led to a misreading of the Supreme Court's intent rather than, deliberate defiance.
The fact that a senior Supreme Court justice says this, that's huge, isn't it? It shifts the narrative.
It's immense significance. It immediately takes it beyond just did she obey or disobey.
Right.
It frames it as possibly a genuine interpretive puzzle. Maybe even an issue with how the order was written, not just how it was read. And if you know Justice Breyer's judicial philosophy, his emphasis on pragmatism, on how law actually works in the real world.
Yeah, he's known for that practical approach.
Exactly. You can see how that shapes his view here. He's looking at the practical realities, the potential unintended consequences of unclear rulings for the judges who have to apply them on the ground.
So his intervention adds real weight to the idea that maybe the problem isn't just individual, but systemic, stemming from the nature of these emergency orders.
I think that's a fair reading. It underscores the difficulty of translating complex legal language, drafted under pressure, into perfectly clear instructions. Breyer's approach often considers the real-world context judges operate in. He's basically asking us to look beyond the accusation and consider the practical hurdles faced by a trial judge trying to make sense of things quickly.
And it makes you wonder, could Breyer's comments also hint, maybe subtly, at disagreements within the Supreme Court itself when the Minerva order was written?
It certainly opens that door for speculation.
Like different justices having different ideas about what it meant, leading to that ambiguity. And could that influence how future orders are read?
It's plausible.
Yeah.
Crafting Supreme Court opinions, especially ones trying for unanimity, often involves compromise. Sometimes strategic ambiguity is part of that compromise.
Okay.
And we see disagreements all the time in dissents and concurrences, right?
Yeah.
Different legal philosophies, different ways of reading texts. Those underlying differences could easily surface in the wording of an order, creating ambiguities that only become obvious when a lower court tries to apply it.
Like that analogy of the engineering team designing something complex.
Exactly. The chief gives an order, but senior engineers have slightly different takes on a key spec. Something goes wrong, and another senior engineer suggests the original spec itself wasn't clear. It shifts the focus. So Breyer's comment could be doing several things. Defending the judicial process, offering a practical explanation, maybe even signaling internally, hey, we need to be clearer next time.
And our sources really hammer home this idea of the pressure cooker environment for judges like Judge Sharma, especially in these high-profile, politically charged, fast-moving cases.
This part is just indispensable for understanding the human side of legal interpretation.
Yeah.
It's not abstract.
Right.
You've got this controversial policy hitting the ground, potentially causing immediate real harm, families affected, maybe deportations looming, basic rights at stake.
Yeah.
Then comes the Supreme Court's order, the Minerva order. But maybe the language unintentionally leaves room to maneuver. And Judge Sharma's right there, clock ticking, public screaming from both sides, knowing the consequences of getting it wrong are huge and possibly irreversible.
Wow.
She has to decide now based on her best reading of the law and the order. Knowing her reading might clash with what the Supreme Court actually intended.
Yeah.
It's not about making excuses for defiance. It's about acknowledging the sheer difficulty of interpreting law under fire, especially when lives are directly impacted. It shows interpretation isn't just some academic game. It's deeply human, under intense pressure.
Try putting yourself in Judge Sharma's position for a second. How do you balance that? Your duty to follow the higher court's order, even if it feels ambiguous, versus the immediate concrete harm you see happening in your courtroom to real people.
It's an immense ethical and legal weight.
You're trying to do justice now, under pressure, with the best interpretation you can muster, but knowing you might be second-guessed, maybe even condemned from above.
Yeah.
It's terrifying.
That is the crucible of trial judging. They're not robots. They're dealing with concrete, often heartbreaking facts, real human suffering right in front of them. So the balancing act is incredibly tough. A judge might see the spirit of the Supreme Court's order as protecting people, right? And then interpret ambiguous language to best achieve that protection, even if that interpretation ends up differing from a narrower reading higher up. It shows why these situations are never black and white. They go right to the core of a judge's role.
And this whole dynamic, this tension between the words on the page and how they're applied, it's not new, is it? It's woven right into American law. Our sources stress that the Supreme Court's orders aren't carved in stone. They are subject to the same interpretive processes as any legal text. Legal understanding itself is fluid. It evolves.
That's such a fundamental point and maybe counterintuitive for some. If we step back and look at the philosophy of law, it shows legal meaning isn't static. It's not fixed forever. It's a living process. It changes with society, with different judicial viewpoints, with public debate.
So the law adapts.
Exactly. This dynamic nature of legal precedent, it's not a bug, it's a feature.
Yeah.
It's how our common law system is designed to stay relevant over time, to adjust to new situations.
It's less like a stone tablet and more like I don't know, a classic novel, Shakespeare.
That's a great way to think about it.
The text is there, but each generation reads it differently, emphasizes different things, sees it through a new lens. Legal texts are kind of similar, but the interpretations have massive real-world consequences.
Precisely. And our sources use Marbury v. Madison, 1803, as a prime example. Landmark case, established judicial review. But even that wasn't perfectly clear-cut initially.
Really? How so?
Well, Chief Justice Marshall was brilliant, asserting the court's power to review laws, but he also strategically avoided a direct clash with President Jefferson's administration that could have been disastrous for the young court. So the scope of that review power, how much the court should restrain itself, that evolved over centuries. Doctrines developed later, like avoiding purely political questions or advisory opinions. It shows that fluidity right from the start.
Fascinating. And the sources also mention the civil rights era.
Yes. Think about Brown v. Board of Education. Historic ruling declaring segregation unconstitutional. But the implementation order? All deliberate speed.
Ah, yes, not exactly specific.
Right. That phrase, maybe intended to build consensus or be practical, created huge ambiguity. It led to decades of resistance, different interpretations by lower courts. It took enormous effort from judges, activists, lawyers to actually make desegregation happen. It shows the system's capacity to grow, to adapt, even if slowly and painfully. And even today, justices disagree strongly in dissenting opinions, right? Those dissents highlight different ways to read the law now, but they also often lay the groundwork for future changes. They keep the conversation alive.
So this whole history, this philosophy of interpretation, it really sets the stage for understanding the core structural tension in the system itself, doesn't it? Essential stuff for anyone trying to understand how it works. Okay, so we've looked at the specific case, the ambiguity, the pressure on judges. Let's zoom out now to the big picture, the architecture of the system. Our sources are very clear. The U.S. judicial system is built on a hierarchical structure with the Supreme Court at its apex. No question about that.
Absolutely fundamental. Lower courts, that's federal district courts, circuit courts of appeal, they're expected, unequivocally, to follow the rulings and precedents set by the Supreme Court, scare decisis.
Right, follow precedent.
It's not just good manners, it's essential for uniformity, making sure the law is applied the same way everywhere. Without that, you'd have chaos. Different legal systems popping up all over the place. But as the sources rightly stress, the reality is far more nuanced. It's not just a simple top-down command structure. And this is where we see that delicate dance between authority and interpretation playing out constantly.
Why does that uniformity matter so much to you listening right now?
Well, imagine if a federal law, say, about clean air or maybe online privacy meant completely different things depending on whether you were in Texas or New York.
Total confusion.
Your rights, your obligations, the consequences for your actions, they could change just by crossing a state line.
Yeah.
That completely undermines the idea of equal justice, right? Creates massive uncertainty, impossible to navigate. Exactly. The hierarchy provides that baseline consistency, that predictability. It lets people and businesses plan, know where they stand. Without it, the rule of law itself starts to crumble.
But it's not rigid.
No, and that's the crucial nuance. Just blindly applying rules from above without looking at the specific facts of a case or without acknowledging ambiguities in the ruling, that can lead to injustice too, or just weird unintended results. So it's this constant balancing act. Certainty versus fairness in context. It's a living dialogue.
And our sources really paint the trial judge's job as exactly that, a constant balancing act under immense pressure. They have to weigh their duty to follow the Supreme Court against their own reading of the law in the specific case in front of them.
Which brings up that huge question. How much real independence should a lower court judge actually have? The system wants both things, doesn't it? Independent judgment down low, unify law from the top.
Yeah, seems like a contradiction almost.
Well, it's a tension. Judges are supposed to be, quote, both independent arbiters of justice and faithful executors of Supreme Court mandates. That concept of judicial independence, protecting judges from political pressure so they can rule impartially, is vital.
Absolutely.
But sometimes that independence seems to bump up against the need for uniformity. It's often subtle in how a judge interprets something, but the consequences are huge on the ground. It means lower court judges aren't just rubber stamps. They have this incredibly complex job of applying abstract rules to concrete facts, which always involves judgment calls, interpretation.
And history shows this tension playing out again and again, right? Sources mention big fights over federalism, states' rights, how to read the Constitution itself.
Landmark cases often revolve around this very balance.
So if you were that judge, how would you handle it? Applying this general rule from the Supreme Court to this unique, maybe really sensitive situation right in front of you, where people's lives are directly affected. It's a heavyweight.
It truly is. And remember, their interpretations aren't made in a bubble. They're shaped by their own legal philosophy. Are they a textualist? Do they believe in a living constitution? By their life experiences, by the specific facts they see.
Right, the human element again.
That individual element is key for justice, tailored to the case, but it also naturally creates the possibility of diverging from what the higher court intended. And boom, there's the tension again. It shows the process is deeply human, interpretive, always balancing.
So this inherent tension between the Supreme Court's authority and the lower court's independence, as the sources say, it's not a flaw, it's a defining characteristic of the whole system.
Exactly. Often missed in the simple versions, but crucial.
The system is designed for this balance. Stability and predictability need to coexist with flexibility and responsiveness.
Lower court judges need that autonomy to handle the messy reality of individual cases, even when Supreme Court precedent is involved. But it's not unlimited autonomy, is it?
No.
It requires deep legal knowledge, commitment to justice, and crucially, respect for that hierarchy. So the tension isn't something to fix, necessarily. It's a dynamic force that ideally makes the system stronger, more adaptable, allows for both stability and evolution.
And going back to dissenting opinions, how do they fit into maintaining that healthy balance? They offer those valuable insights, right?
They're vital. They keep alternative arguments alive. They poke holes in the majority's reasoning sometimes. They can plant seeds for future legal shifts.
Like roadmaps for later.
Exactly. They show that law isn't always settled, that smart people can disagree. That internal debate is crucial for the law's ability to adapt and maintain legitimacy over time. Keeps the system honest, in a way.
Now, all this internal dynamic, this tension, it has major effects outside the courtroom, doesn't it? Especially on public trust. Our sources are stark. The public's trust in the judiciary rests, in part, on the perception of fairness, consistency, and adherence to established legal principles.
This is absolutely critical, because public trust is the foundation. It's where the courts get their real power, their moral authority.
Right.
So when you have a case like Judge Sharma's, an accusation of defying the Supreme Court, it can seriously erode public confidence in the entire system. Without that trust, it's much harder for court decisions to be accepted, to be followed. The whole thing relies on legitimacy.
And if people perceive a lack of consistency, if the law seems like a lottery depending on the judge, that directly hits their faith in fairness, doesn't it?
Absolutely. Public trust is, as the sources say, a fragile commodity. Takes ages to build, can be damaged quickly.
So why should you, listening, care deeply about this? Because if the judiciary loses public trust, it struggles to enforce the rule of law. And that affects everything: economic stability, social order, safety. If people don't believe the courts are fair or consistent, they lose faith in the system itself. That predictability we talked about, it's vital for a functioning society.
Uncertainty about how Supreme Court rulings are interpreted or enforced, like at the Minerva order, just shatters that predictability, leads to cynicism, maybe disillusionment with the whole legal process.
So these instances of perceived defiance, or even just confusion about rulings, they can erode that trust, potentially leading people to tune out or become deeply skeptical.
And remember, the courts don't have an army or control the budget like the other branches. Their power comes from legitimacy. Anything that shakes that legitimacy is a serious threat to their role in our democracy. Managing this authority-independence tension isn't just academic, it's essential for the health of the republic.
And often this erosion of trust isn't just happening in a vacuum. It gets amplified, sometimes maybe even distorted by another powerful force, the media.
Yeah, this is a really interesting and sometimes tricky aspect. The sources point out that the media plays a significant role in shaping public perception of these cases.
How so?
Well, the challenge is that news coverage, especially today, with quick headlines and sound bites, often simplifies the complexities of the legal issues involved.
Right, nuance gets lost.
Exactly. Those headlines rarely capture the fine points of legal interpretation or the built-in tensions we've been discussing or the pressures judges face. That simplification, while maybe necessary for reaching a broad audience, can lead to a distorted public understanding. And that, in turn, can fuel anger or distrust.
So, thinking about how you consume news, do you feel you get the full picture on complex legal stories? Or is it often the dramatic headline that grabs you, maybe missing the crucial context behind a judge's decision?
It raises big questions about responsible journalism, doesn't it? How to inform accurately without oversimplifying. The media has this tough job of translating dense legal stuff into something accessible. But the risk is always that the why and how, the interpretive challenges, the competing principles, the human factors get smoothed over. And that can contribute to public misunderstanding, making it harder for people to appreciate the judiciary's complex role, potentially weakening trust.
Okay, so we've laid out the complexities, the tensions, the pressures, the risks to public trust. How do we move forward? Our sources don't just diagnose the problem, they also suggest some potential paths, specifically strategies to improve clarity and consistency in Supreme Court orders.
Right. The main ideas focus on things like using more precise language in orders, especially those emergency ones, providing more detailed explanations of the reasoning behind the rulings.
So everyone understands the why.
Exactly. And maybe including more specific guidelines for application for the lower courts. The thinking is, if the guidance from the top is clearer, more explicit, it could reduce ambiguity, minimize the chances for genuine misinterpretation like Judge Sharma was accused of.
So what could that look like in practice? Maybe the Supreme Court issues an order and also like an FAQ document for judges explaining tricky bits.
That's one possibility.
Or maybe they just dedicate more time, even in emergencies, to really vetting the language for clarity, assigning a justice to double-check it. And the sources also mention the role of legal scholars, right? Their analysis can help clarify things, too.
But there's a trade-off here, and it's important. The sources acknowledge this, too.
What's the trade-off?
Well, while clearer, more detailed directives might cut down on misinterpretations, they could also stifle the flexibility that lower court judges need. Remember, they have to apply these rules to unique, sometimes unforeseen facts on the ground.
So too much clarity could backfire. Could become micromanagement.
Potentially. It's a really fine line. You want enough guidance for consistency, but not so much that you hamstring the lower court judges, undermining their independence and their ability to tailor justice to the specific case. Overly prescriptive rules from the top might prevent judges from responding effectively to local realities they see firsthand.
Okay, so clearer orders are part of it, but not the whole solution. What else? The sources also stress improving communication within the judiciary, a more collaborative approach.
Absolutely.
Yeah.
This is just as crucial. It's not just about the words and the orders. It's about things like improved training and resources for lower court judges. Training specifically focused on how to interpret Supreme Court orders, how to navigate decision-making under pressure.
Ongoing professional development.
Yes. And the sources suggest creating more spaces for dialogue. Things like open forums, collaborative workshops, maybe even more structured feedback mechanisms.
Feedback going up the chain.
Potentially. Imagine a way, maybe anonymous, for lower court judges to ask clarifying questions about orders directly to the Supreme Court or its staff. That could clear up ambiguities before they become big problems, foster more transparency, more understanding.
That makes sense, like in any field, right? Medicine, science, ongoing training, open communication, feedback loops. It all leads to better outcomes, fewer errors, especially important in the judiciary where the stakes are so high.
Exactly. These kinds of collaborative approaches move away from a strict top-down model. They value shared understanding, mutual respect, continuous learning throughout the whole system. It recognizes that interpretation is a two-way street. Both the court issuing the order and the court applying it have roles in ensuring clarity and justice. It's about building a stronger, more unified judiciary while still protecting that vital independence at every level.
And ultimately, our sources remind us the world keeps changing. Evolving social and political landscapes introduce new complexities, forcing the courts to constantly navigate shifting ethical and legal terrain. This isn't a static system.
No, it absolutely demands ongoing dialogue and continuous reform.
The pursuit of justice isn't something you achieve and then you're done.
It's a continuous process, as the sources say.
Yeah.
An ongoing journey. It requires constant vigilance, adaptation, a commitment to fairness for everyone. The case we discussed, Judge Sharma and the Minerva Order, it really forces us to confront these fundamental questions: authority versus independence, the role of interpretation, the importance of public trust. The image of justice itself, it remains a work in progress, constantly refined and improved, an ideal we keep striving for.
So let's bring it all together. What does this deep dive mean for you, trying to understand the American legal system? We've looked at that fascinating tension between authority and independence, sparked by that case of alleged defiance. We saw that Supreme Court orders aren't always perfectly clear.
Mhm.
We explored the intense pressure cooker environment judges work in, and how history, like Marbury v. Madison, shows interpretation is always dynamic, always evolving.
And we emphasize that this tension, authority versus independence, it's not a flaw. It's fundamental.
Yeah.
It requires constantly balancing uniformity with the flexibility needed for real justice in individual cases. And we saw how fragile public trust is, affected not just by court actions, but by how these complex issues get filtered through the media.
So, the key takeaways. There's a need for clearer communication from the top, from the Supreme Court. The absolute importance of judicial independence even within that hierarchy. And underlying everything, respect for the rule of law, both the written rules and how they're interpreted and lived out.
And we also touched on those practical steps:
Yeah.
better training, more dialogue, feedback loops that can strengthen the whole system, make it more collaborative, more effective.
So, as we finish up, here's a final thought to chew on. These complexities we've discussed, they aren't just for lawyers, they affect all of us, they shape our society. So how do you, as an informed citizen, weigh these competing needs? The need for a predictable, unified legal system where the law is the same for everyone everywhere, versus the equally critical need to give judges the independence, the flexibility to interpret that law fairly in unique, specific, often difficult human situations. It's a fundamental question about the kind of justice we want.
The specific case of the Minerva Order might fade, but the deep issues it surfaces: authority, independence, interpretation, trust, they aren't going away. They demand ongoing thought, continued discussion from all of us. The strength of our judiciary really depends on navigating this delicate ongoing balance. How can we, collectively, make sure that vital work of refining and reforming continues, always pushing towards a fairer, more just future?